Welcome to the third and final day of the 2021 U.S. Space Command Legal Conference presented to you by the U.S. Air Force Academy's Law, Technology, and Warfare Research Cell, together with the U.S. Space Command Office of the Staff Judge Advocate. Once again, my name is Professor Jeff Biller, and along with Lieutenant Colonel Tim Goins, Lieutenant Colonel Mark Rasmussen, and Major Jeremy Gruner, we are your conference hosts. If you have any questions or concerns during the conference or after, please contact us through the chat or via our email, ltwrc@usafa.edu. As a reminder, if you have concerns or issues to relay to us as your conference host, please use the chat function. If you have questions for our speakers, please use the Q&A. We have one panel this morning on operational law and military space operations, after which we will offer some closing remarks for the conference, as we will then switch to the breakout rooms. Everyone should have received links for the breakout sessions. If not, please let us know in the chat and we'll pass that information along. I encourage everyone to participate in the breakouts, as it will be a chance for some more informal conversations and to ask all those questions we didn't have time to address. Following the breakouts, we will have an extended break until 13:30 Mountain Time to allow those attending the classified session to travel. Finally, another reminder that all opinions and thoughts expressed as part of the conference should be considered the personal opinions of the speakers unless otherwise indicated. Now I'm going to turn it over to Lieutenant Commander Rasmussen to introduce our final panel. Over to you, Mark.
Thank you, Jeff, and good morning, everyone, and welcome again to the final day of our inaugural conference. For those of you unable to attend, I am, again, Lieutenant Commander Mark Rasmussen. I'm a national security law attorney here at Space Command, and it is my distinct pleasure to introduce this next panel of my colleagues and friends that will discuss a topic near and dear to me, military space operations in the law. If you note each of the panelist positions, you'll see that we have representation spanning the spectrum of DoD space operations, really truly across the enterprise in terms of military space operations, from the component level at CIFSIC to the combatant command level here at SpaceCom, to the joint staff, and to the Office of the Secretary of Defense. And so given that, I think each of these distinguished panelists will bring a unique perspective and their own respective insight. Our moderator for the panel is a very impressive young man, Cadet First Class Aryemis Brown. Cadet Brown is in his final year at the Air Force Academy, where he majors in legal studies and humanities. In May, Ari will commission into the United States Space Force as a space operator. His research interests are space and cyberspace law, technology, policy, and philosophy, as well as leadership and character development. Ari commanded the Air Force Cadet Wings as Commander of Troops, serving as the highest ranking cadet at the Academy. His overall order of merit, combining athletic, military, and academic factors, is 2 out of 1,059. He was named a Truman Scholar and Rhodes Scholar in 2020. He will be spending the next year at the University of Oxford pursuing a Master of Philosophy in International Relations. It's very impressive. Ari, the floor is yours.
Thank you for the kind introduction, sir, and welcome to the final day of the United States Space Command Legal Conference. Today's operational law and space operations panel will highlight the view and considerations of the tactical operator, the military professionals that drive our national security mission in outer space. We hope to step into their mind, consider their perspective, and ask their questions. I'm excited to learn about this topic with you and encourage you to ask questions. You may write your questions using the Zoom Q&A function, and we will try to address as many as able during the question and answer portion of the panel. If you would like to address your questions to a specific panelist, please include their name in your question. Please remember that between our unclassified Zoom setting and the scope of the panel, we may not be able to address all topics related to military space. We will begin today's discussion with opening comments by each of the panelists. We will then transition to a panel discussion on fascinating and current questions in space operational law. We will end today's panel with your questions and your ideas. It is now my pleasure to introduce our panelists. Ms. Vida M. Antolin-Jenkins is the Senior Associate Deputy Legal Counsel for Intelligence and has practiced law for the Department of Defense Office of General Counsel since August of 2013, providing legal advice to the DoD senior leadership, particularly the Undersecretaries of Defense for Intelligence and Security, Policy, and Acquisition and Sustainment, as well as the DoD Special Access Program Central Office. Her portfolio focuses on space and special access programs and sensitive reconnaissance operations. She has been a practicing attorney since her admission to the Pennsylvania Bar in 1981. Ms. AJ, as she is also known, has 6 years of experience as a sole practitioner and 23 years of experience as a uniformed lawyer with the U.S. Navy's Judge Advocate General Corps, retiring in 2013 as a captain. She received her Bachelor's of Arts in International Relations from the University of Pennsylvania in 1976, obtained her Juris Doctorate cum laude from Washington College of Law, American University in 1981, and completed a Master of Laws in International and Comparative Law with distinction from Georgetown University Law Center in 2003. Welcome, Ms. AJ. Since 2020, Commander Matt Wooten has been assigned to the Office of the Legal Counsel to the Chairman of the Joint Chiefs of Staff. His current portfolio includes space operations and policy. From 2017 to 2020, Commander Wooten served as a national security law attorney at U.S. Indo-Pacific Command, where he covered the cyber, space, and information operations portfolios. Commander Wooten's operational deployments include Iraq, Afghanistan, East Africa, and twice aboard the aircraft carrier USS Dwight D. Eisenhower. Welcome, Commander Wooten. Our next panelist is Lieutenant Colonel Joshua Wolff, an international and operational law attorney from United States Space Command. He advises the USSPACECOM leadership and staff on operational, national security, and international law issues affecting space operations. Lieutenant Colonel Wolff holds a Bachelor of Science from the United States Military Academy, a JD from the College of William and Mary, and an LLM in Space, Cyber, and Telecommunications Law from the University of Nebraska. Lieutenant Colonel Wolff's assignments include serving as a scout platoon leader in Iraq, the senior trial counsel for the 1st Corps in Joint Base Lewis McChord, the brigade judge advocate for the 173rd Infantry Brigade Combat Team Airborne in Vicenza, Italy, and an associate professor of administrative and civil law at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. Welcome, Lieutenant Colonel Wolff. And finally, we have Major Matthew Zellner. Major Zellner is the Chief of Space, Operations, and International Law at the Combined Force Space Component Command, Vandenberg Air Force Base, California. In this role, he advises the dual-hatted command with 16,000 personnel and 200 units at 58 worldwide locations, providing space effects to terrestrial operations. Major Zellner received his bachelor's from the University of Missouri, master's and Juris Doctorate from the University of Oklahoma, and LLM in International Law from Columbia University. He has previously served in a range of legal positions for the U.S. Air Force and U.S. Space Force, including 4 overseas assignments and deployments. Welcome, Major Zellner. And with that, our panelists prepared a few opening remarks for you on the topic. We'll begin with Ms. AJ. Over to you, ma'am.
Good morning, good afternoon to some of us. Cadet Brown, thank you very much for the introductions, and thank you for doing such a great job of herding the cats for this panel. I know it's been quite a bit of work for you. It is truly an honor and a privilege to be part of this group at this inaugural USSPACECOM Legal Conference. And what an exciting time to be a space lawyer. I'd like to give a quick sketch about what the operational lawyer does at the Office of the Secretary of Defense level. I often think that my past self owes a sincere apology to my present self, since as a young Navy JAG deployed on the USS Wasp off the coast of Somalia, I said very unflattering things about the lawyers at the highest level of the department, who clearly didn't have any understanding or appreciation of the need for speed or decisions on a tactically relevant timeline. I may have called them the abominable no men. Now I am one. So let's talk about where the authority for the conduct of any military operations comes from. It's essentially a pyramid of authorizations from the bedrock by the president that in his or her constitutional role as the commander-in-chief, he or she wants to define military engagements in a particular warfighting domain and a particular geographically defined area of operations. He or she does this in primarily two ways. First, there's the broad direction in the issuance of national policy documents, like President Biden's March 2021 interim national security strategic guidance, and then the national defense strategy, and then further neck down to, for example, the national intelligence strategy of 2019 or the national strategy for other matters, as well as through various executive orders. Then there's the more particular policy guidance for specific areas or issues that, again, are often reflected in presidential policy documents. Every president since President Truman has issued a series of executive orders or memoranda on national security issues, some classified, a few of them unclassified. The names of these policy documents have varied with each administration, so there's a small alphabet soup of them, such as President Reagan's National Security Decision Directives, President G.H.W. Bush's National Security Directives, President Obama's Presidential Policy Directives, or President Trump's National Security Presidential Memoranda. President Biden is issuing National Security Memoranda. Now, I listed all of these various names, not as a historical note, but to really alert you, the practitioners, that an incoming president does not cancel all preceding guidance, and that unless explicitly canceled by another presidential action, the presidential policy documents may remain in effect for quite a long time. And there is another factor that's really important for the practitioners with respect to these documents, that many are not only classified, they're also not authorized for broad distribution. We at the OSD level receive them, but we may be precluded from providing copies of those down the chain of command to the operational lawyers at the pointy end of the spear. So you have to depend on us to apply the policy guidance and the restrictions of those policies at this level, which makes it difficult for you to practice because you don't know what you don't know. Then there's furthermore presidential guidance and authorization that is focused very particularly on specific operations, from broad campaigns that are approved by the president to individual operations that are approved in incremental stages. For an extremely sensitive operation, there may be an iterative engagement between the president and the Secretary of Defense for each stage of an operation. One particular example of that in which I was personally involved was when I served in Chairman's Legal, and it was the operation against the Somali pirates who had captured Captain Phillips and the Maersk, Alabama. Each stage of that operation required the president's authorization. And frankly, I was on the phone with the OSD lawyers talking about the next set of ROE when the pirates showed hostile intent toward Captain Phillips and were shot. But that gives you some idea of what we do for a living. So what does the operational approval process look like from here? First, everybody needs to be aware that there's not a one-size-fits-all process. There are three main processes for gaining approval for operations, and discussions on those could take more than an hour and are part of various courses that you can take. The three processes briefly named are the Secretary of Defense Orders Book process, which is primarily run, most of these are primarily run out of the Joint Staff. The Integrated Joint Special Technical Operations, or IGISTO process, which is really a subset of the SDOB, or is it Secretary of Defense Orders Book process, and the Sensitive Reconnaissance Operations process. I just want to give you a quick parenthetical note that on April 5th, the Deputy Secretary of Defense signed a memo on the interim IGISTO policy, which has made a change to the IGISTO process. For those of you who need to know what that might be, let me know. We can distribute it further. All right. Fairly hot off the press. Why do you need to know the processes? It helps you to know who the audience will be for a particular operational proposal. And you can go to the references and figure out what the authority level is. This can matter a lot because if you know that an operational proposal will have to go across the river, i.e. to the White House, then you know to be particularly vigilant in helping your command or commander to prepare documents that are readable to a non-DoD audience. Making certain that the non-DoD reader doesn't feel as though they're missing the decoder ring when reading operational proposals can be really key to effectively selling that operational proposal for approval. So what do we look at? We look, first of all, to see if the operational proposal has been shared and vetted by all the commanders and DoD entities who have a stake in the matter. There are a number of guidance documents that set that out. The overarching document is, again, a presidentially approved document, the Unified Command Plan, and the Forces 4 documents. These define the areas of responsibility and the specific tasks that the president assigns to the combatant commander. And there's direction in that document that tells the combatant commander when and who to coordinate with. For broad scope operations, which already have a presidentially approved execute order, the order usually has language directing certain coordination and interaction in the preparation of specific operational proposals. Part of the OSD legal analysis is to see if the direction that is contained in these policy documents or in the executive order or execute order have actually been used. Here's a practice tip. If your commander has been delegated authority to conduct certain types of operations, he or she should not ask for authority to do that operation. It is quite interesting how often an operational proposal arrives to our level and we conclude that the commander already had the authority to conduct the desired operation. While the commander can always decide as a matter of prudence to inform the secretary that he or she is exercising previously granted authority, the transmitting document should make clear that the concept of operations is being sent for information and not vetting. A really important thing to always have handy is the statutory authority section of Title 10 that talks about the role of the combatant commander and the relationship with the secretary. So we look at all of those things, and then we also replow all the ground that the operational lawyers closer to the operations have done with respect to the big international law of armed conflict questions. So we take a close look at the legal opinions that come to us. We re-examine all of the presumptions and analyses there. And we read every single one of those legal opinions, and they are extraordinarily helpful. So I'm going to tie this up because I can see I'm running over. Sorry about that, Cadet Brown. Here are two vital practice tips. If the legal opinion you've developed in the course of sending something forward as an operational proposal required you to get more information from your clients in order to do the legal review, make certain that the package being sent forward has that factual information somewhere other than your legal opinion. We can't rely on the recitation of facts in the legal opinion as the basis for our legal analysis. It's, in a sense, hearsay. Facts are the bedrock of every legal opinion, and the source of those facts is pertinent. So if you go and have a discussion with operators to clarify facts for your legal opinion, you're going to have to make them put it in writing and make sure that it's in the actual materials being sent forth. And secondly, rocket science really, really matters in the development and writing of legal opinions about space operations. Anything that you as an operational lawyer can do to improve your knowledge of the limiting factors of the physics of space will help you to be a better legal analyst. Helping the client set out with precision and clarity how operations are conducted and what the effects of these highly technical capabilities in an unfamiliar environment in a way that's understandable to the layperson really is key to enhancing the approval process. Remember that I'm likely going to have to sit in an interagency lawyers group and explain in very plain English what the rocket science test said. You don't want me translating rocket science. Thank you.
Thank you, Ms. AJ. We always appreciate your insight. Commander Wooten, over to you, sir.
Thanks, Cadet Brown. So first, I'd like to say I'm very honored to be a part of this panel, especially with Ms. Antolin-Jenkins, because most of what I learned about space law, I learned sitting in her office, having conversations with her. So it is certainly a privilege to be on the same panel as she. I'd like to start my comments with something that I think this group would all agree with. Really a non-controversial statement that I think lawyers from all services need to be exposed to space law. And I think most of the people in this conference would agree with that. I will say, though, that realization only came to me kind of later in my career. I would say probably about 10 years ago, I came to the realization, hey, if you're going to be an operational law attorney or a national security law attorney, you need to know about cyber operations. And then being a little bit slow on the uptake, it was probably about 5 years ago that I realized, hey, another key area that every lawyer that's going to do operational law needs to know about is information operations. And then, unfortunately, it was probably about 3 years ago when I got to USSPACECOM and got assigned the space portfolio that I realized, every single lawyer needs to have some basic understanding of space law. And because it's really important to understanding the joint all-domain way that we as a joint force conduct warfighting. And I would say that when I started off at a geographic combatant command, one that's not SPACECOM, and now as I've moved to the joint staff, over the years, I've seen the percentage of my workload that relates to either space operations or space policy increase every single year. Ultimately, when I've seen this increase, it's not a particular space law issue or space law policy that I tend to have an issue or a question come from the client. Usually what happens is it's a complex legal analysis on a plan or an operation, and space law is one aspect of my review of that plan or that operation. And if you don't have that space law knowledge, you'll just completely miss that part of the issue that might be deep down in that analysis. And I'm 100% sure that I'm going to see the percent of space issues that are arising and the proposed operations that come up through the joint staff, as well as the plans that come up through the joint staff, that those are going to increase. Again, I don't think any of those are any comments that the group that decided to set aside the time to attend the Space Legal Conference probably don't already know. But I share that because I do speak to a lot of lawyers at the GCCs, et cetera. And I always kind of pound the table and say, hey, if you're not learning about space law, you need to. And with that, I'll turn it back to Ari.
Thank you, sir. Colonel Wolff, over to you.
Thanks, Ari. And I do want to just echo Commander Wooten's note that it's an honor to be on a panel with, to me, some of the sharpest military space law folks we have. So I wanted to take just a couple minutes for my opening remarks and talk a little bit what it means or what legal advice to operations looks like at the combatant command level. So sort of a level down from what Ms. Antolin-Jenkins was talking about. And I imagine most people tuning into this section are familiar with the difference, but to echo what Rear Admiral Bernanke said Wednesday, if you remember, there's a dichotomy in the DoD of the services that do the organize, train, and equip. They prepare those capabilities, and then the Secretary of Defense assigns them to the combatant commands for operations. And those operations obviously span the entire spectrum from the standard day-to-day interoperability, readiness type of things, all the way up to, in the event of a conflict, to the warfighting side. So when we think about operations, the way I'd like to frame how our role as legal advisors is starts with a phrase that I like to say that, operations are conducted by operators who are executing plans. So not far from the most brilliant thing you're going to hear here today, but the reason I provide that framework is because it really keys into a lot of what Major Zellner and I do at the combatant command and the component level. At my level, probably much more on the plan side, and Major Zellner being closer to the operations, but all plans are going to have legal issues, as Ms. AJ had sort of hinted at there or described. Whether that's the very deliberate long-term plans, or if it's a very fast-moving, high-priority action, they're all going to have legal issues. And so being tied in with the planners and a part of their process is obviously vital to being effective at our job. And on the operator side, one of the most important things we do when providing legal analysis is characterizing the proposed action in legally significant terms. And you just cannot do that if you don't have a pretty good understanding of what is going on with the actual operation. And that could mean getting a detailed understanding of the technology. It's not uncommon to have a space operations expert whiteboarding something for my simple mind to try to understand exactly what's happening so that I can bend that activity into what might have some legal significance. So that being kind of the how it works, what we're looking at in general when we're talking about what are the legal issues, it's important, I think, that we consider it in two different sides. There's the legal issues or the law, and then there's policy, as again, Ms. AJ had hinted at. On the legal side, it's obviously a big international law component, certainly some domestic law too, whether we're talking some of those Title 10 combatant command authorities on the domestic side that Ms. AJ said, or even sometimes Title 22 or Title 50 type of analysis that's required. And then on the policy side is where things can get even more, in my mind, sort of complicated or complex. And to be honest, that's where understanding the specifics of the operation and the capabilities at stake is vital. But the reason I say it's key to keep in mind those two things and what's different is, number one, leaders expect the legal team, part of the legal analysis, to address both of them. So even if it's policy and not law, they expect the judge advocates really to be on the lookout for that. And I think you heard that for those of you that heard Admiral Bernanke's remarks on Wednesday. I think that was pretty clear. And secondly, I think what's really important is that policy is something implemented. If the legal boundaries are out here, policy is going to bring you in here to try to keep you wherever the policymaker is most comfortable on the gray area, so to speak, on the boundaries of the law. And for that reason, there are usually exceptions to policy, and whoever implemented that policy has designated an approval authority for an exception. Obviously, the law doesn't really work that way. The law side would be different. So understanding to what extent a policy is implementing a law or whether it's essentially restating it is critical, I think, in that, particularly in that planning process, because if you're not involved early and there's one of those type of issues where someone assumes that there might be an exception available, if you're not involved early, that plan can develop a long ways before folks identify that there's actually a significant issue with how they're looking at doing it. The only other thing I wanted to mention before turning it over is one other thing we do at the Combatant Command is identifying or what I describe as coordination. So obviously Space Command has an area of responsibility, and at this point in the conference, you can probably all say it with me, right? It's 100 kilometers above sea level and beyond. And but obviously things that we do are likely to have effects in either other areas of responsibility for other combatant commands, or that we just have stakeholders in other branches of government or even allies and partners. And so understanding and seeing those things early, part of our role is to sort of send that message up or over to a sister combatant command to try to sort things out early. On the legal side, obviously, we like to settle that informally, and that way when there's a VTC, we've sorted that out and the operators can fight about how the plan should look, but we've identified and smoothed out the legal issues ahead of time. So I'll stop there and turn it back over to you, Ari, and looking forward to the questions. Thanks.
Thank you, sir. And to our final panelist, Major Zellner.
Thank you so much, Cadet Brown, and echoing, it's an honor to be here and looking at the agenda. It feels pretty special to not necessarily be on the shoulders of giants, but get to be on panels and part of a conference with them. And I've realized my ultimate goal in this is to retire before Cadet Brown takes my job. So hopefully we can expedite that. But my goal right now is to describe the role of space ops law attorneys at the tactical or execution level. So you've heard from the joint staff, the Secretary of Defense level, you've learned from the combatant command perspective. So now at the execution level, we're a joint component of Space Command. And then also we have Combined Space Operations Center, the C2 node for all the operations happening globally. So just a few notes that often in planning and gaining approvals for operations, we're actually subordinate to many higher levels, some of which are on this panel right now. However, when executing, to understand that the buck truly stops with us, whereby we are directly advising the operators executing the mission. So understanding you don't have the degrees of separation that you might at other commands or levels. Because of this, preventative law is extremely important, and think legal education and training, not necessarily for other legal professionals, but for the planners and operators that will be executing the missions. So the reason is that can actually prevent fires in planning and operations versus simply having to put the fires out if no one knows legal lefts and rights. So an example is Combined Force Space Component Command, where I work. They have more than 75 tactical units. So there's no possible way as a legal advisor to advise everything, every action that everybody does. So they need to have some knowledge base, so at least they know where to go, where to ask, and know some basic parameters. And so trying to get out in front of missions, trying to get out in front of planning and execution and operations, where you can prepare them to know not only what's kind of my baseline look like, but when things change or when inputs happen, what are their legal lefts and rights? And I think it's important for legal advisors at our level to make clear the intent of your role. So our role is to protect the command, protect the Air Force, protect the Space Force as our client, and we're an enabling function. So we want to maximize legally available options for commanders, and we want to help meet the commander's intent. So we do not want to be just a rubber stamp yes or no, just because you're not sure, you're nervous, you don't want blowback, or you think it's safer. If yes, and you've analyzed it, as kind of Miss AJ was saying with her legal review discussion, if it's yes, great, communicate that. If it's no, don't just say no. You have to tell them why and maybe what they could do instead. So that's a huge gap that I think a lot of legal advisors don't quite make, because these people at the operational level are wanting to execute and they understand the urgencies and the exigencies. And so you have to provide that advice to guide them, not just say no and walk out of the room. We must also know, or at least understand, the general nature or where to find the compendium of controlling orders, or at least, like I said, have them readily accessible. So we span the globe in our operations. We're all over the planet, our folks. And so there are controlling orders coming from those levels that were previously briefed in this panel. They're coming down from those levels and they apply to each of these individual operations. If we're not versed in those, or at least fairly familiar, or know where to look or how to engage with getting them when questions come up, we can't advise. And a lot of times these situations arise where it's a fast moving situation. And so if you don't even understand the laydown and the execution orders or the operations orders that are controlling it, it's very hard to advise. And you have to say, well, stop, give me a couple days to review it. that's usually unsatisfactory at an operational level. And then finally, to fully perform our job function, we have to at least have a basic understanding of orbital mechanics and system functions. I often say that when I got here, I knew that there was 8, arguably 9 planets. I know it changes every few years, and that was virtually the extent of my knowledge. But I quickly learned that to really advise it at the operational level, you have to understand the finer points. You don't have to become an orbital mechanics expert, and you don't have to understand the ascending nodes and all of that. But you do have to understand some basics and basics of system functions, because when you're advising operations and you're taking, let's say, the orders you have, you understand law of armed conflict, you understand these things, to then apply them to a fact-based situation, you have to understand. So there's no way to adequately review those and then advise. Additionally, this helps in planning before execution, where as they're trying to develop plans, you can say, okay, well, I understand this is what you're trying to do. I know our authority is restricted to this, so maybe we can do X, Y, or Z instead. Or in fact, a good news story is if they're trying to do exactly what an authority might suggest, and you know that based off your understanding of the systems, the capabilities, the orbital mechanics, the environment, both terrestrial and outer space, and then you can give really adequate legal opinions and advice where everybody knows and feels comfortable that they are within their lefts and rights. So that's all I have. Thank you, Cadet Brown, and thank you for having me. I'll stand by for questions along with the rest of the panel.
Awesome. Thank you, sir. And we're getting to the point where we're receiving many wonderful questions from the audience. So let me pose to the panel. Senior military leaders describe outer space as a warfighting domain, while the average citizen might describe it as the Wild West. What is your legal perspective, and are these fair characterizations? Ms. AJ, over to you.
There we go, I think. Okay. So much like when cyberspace operations were starting and everyone was clutching their pearls going, there's no law, there's no law. I am distressed by the characterization that, you know, it's the Wild West. First of all, historically speaking, it's not the Wild West unless you consider 50 years of positive law, or over 50 years of positive law in the space to be pertinent. I mean, the Outer Space Treaty went into effect in 1967. Even more important and pertinent to the practice of space law, the ITU organization, the International Telecommunications Union organization, was founded on May 17th in 1865. What is unfamiliar to us, because space has been looked at as primarily a support domain, is that we are having to work a little harder to take the law that is extant, and there's, you know, the law of military operations, LOAC, international law writ large, is now being applied to operations that are unfamiliar. But it's a Wild West implies that there's no law to apply, and I think that that's a very unfortunate characterization. There's plenty of law to apply. We just need to get to work.
Thank you, Ms. AJ. I'm going to follow that one up with a question we've received from our Michael listener in the audience. Reoccurring themes in this conference have been norms, rules, frameworks, etc. for outer space. The loose thread is when conflict erupts and whether those rules will be followed. How will the US and its allies deal with an adversary like the PRK and PLA, whose doctrine includes throwing out the rules to gain a strategic advantage at the beginning and during hostilities?
Ari, I could start on that. I think it's a a good question. I think the key is, at least, and this is just Josh Wolff talking, but I think that the discussion and focus on the norms that you may have heard throughout different parts of this conference are less aimed at the event of an armed conflict. You know, I think as Professor Vonderduck went over yesterday, there's all kinds of issues to look at the extant law, the lex lata for how we would view that, the LOAC in with a conflict that involves space elements of it. But so I think that the norms piece is really the day-to-day. What is, for example, the Outer Space Treaty has an obligation to operate with due regard. What does that mean? And I think the idea is, well, if we have a little bit more of an understanding of norms of behavior, that might give us a little better picture of what that means, so that we can do other things, so that in the event we're concerned about a conflict, we feel like we have a little bit better framework to a more complete picture to look at activity and try to characterize it. So again, I'm not sure how it would look in conflict, but to my mind, when I hear that conversation, I don't think that I think it's much less about the event of an armed conflict, and I think it's much more about how do we avoid a miscalculation or a misunderstanding with strategic consequences.
Cadet Brown, if I can also chime in, I think there's another factor here, which is important to remember. So there is the law of armed conflict, and then there is the peacetime law, right? So we're saying that we anticipate some of our adversaries throwing out the rule book, if you will. Well, which part of the rule book? So the decision to enter into conflict is a very profound national decision. But it also, once the decision is made, it changes the rule book that you're depending on. So I think it's very important for us to be developing the non-binding norms and all of these tenets of behavior and all of that. But the other part of the law with respect to conflict, period, is that while there is a, if you will, not so much a compendium, but a range of activity, the question of what constitutes, for example, armed attack is something that is debated in all domains, right? And when do you move from a situation where peacetime rules are applicable, and when have you flipped it to the other, is something that, yes, we will have to develop in space as we have elsewhere, but it's, it is part of the hard work that has to be done with respect to changing our perspective on space as a warfighting domain.
Thank you, Ms. AJ. And Major Zellner, let me quickly pose to you, when I'm heading into outer space where I won't have access to my online space reference library, what am I putting on the reference thumb drive that I'm including in my minimum cargo allowance?
Thanks, Cadet Brown. That's a great question. So I think there's kind of three different things that you're going to be trying to juggle at the same time, certainly as an advisor or even just a lay person going up into space. So first, you have to deal with all the rules, all the regulations, and then all of the factors surrounding space flight safety and maintenance of operations, because we all have to remember that at the end of the day, while it's sometimes easy for legal advisors to not necessarily be in the shoes of those on the front lines, let's say, dealing with issues and trying to troubleshoot, you have to understand that keeping people safe, keeping even objects safe, certainly with outer space with the risk of debris, that's going to be the number one thing that you're going to want in your library, in your thumb drive, whatever rules, whatever regulations, whatever sorts of orbital parameters that you need to understand, and then licenses and things like that are really all designed to keep you safe. I think secondly, then you need to be researching and understanding how to handle any sorts of contingency situations that occur on orbit. So if orbital debris is created, if you have something incoming, if you have something inbound towards you, what are your SOPs, your standard operating procedures, but also what are the legalities of that? What are the legalities of orbital slots and how we've been regulated on where we can fly, where we can't fly, what orbits are going to be safe, understanding the projections of both spaceflight tracking of objects, man-made objects, debris, unidentified objects, understanding how to fit all of that within the puzzle, and the legal regime that governs that is going to be crucial. And then finally, really, then the last step is really becoming the ops legal advisor. So understanding we have to help whatever mission commander it is assess any sort of situation or potential adversary behavior. So with that, we also have to understand response options. So I would say it's kind of a two-pronged test there, where you first try to ascertain what is actually going on. And we have several classified documents and things that I would want to take with me that tell us, okay, here are potential indicators for X, Y, and Z when things are happening. And then secondly, based off of those understandings as you're advising that mission commander, what are our legal authorities, both from a joint staff or secretary of defense or whatever level it is, however the command structure has been given. And then secondly, what are those response options available both to our mission commander and then whatever we need to request for somebody else. So those compendium of documents and orders, Department of Defense regulations, instructions, maybe your localized special instructions, your spins, your SOPs, all those things that are going to govern, okay, what if something bad happens? Because Mike Tyson used to say everything goes out the window once you get punched in the face. And so in a military context, very rarely do missions go exactly as planned. So understanding and thinking through as lawyers do, let's say in a family law case with a divorce or a child custody, you have to think several steps ahead to say, okay, but what if X happens? What if Y happens? What if Z happens? I need to have my book ready. I need to have my answers ready because I'm anticipating things are going to happen. And when they do, quite literally, and probably everybody on the panel has been there, a commander, a general, whatever, is going to look at you and say, what can I do, Jag? Or what should I do? That really happens. So having that basis where you don't have to go spend a day and a half researching, you have it there and anticipating those issues. And finally, that kind of ties back to my final point in my remarks, which was you have to understand that orbital environment and how operations are working as an attorney to be able to anticipate. So I need to know what orbital plane are we looking at? What's near us? Am I in lower Earth orbit or middle Earth orbit? What is that environment looking like? And what are my laws and regulations with it? Thanks so much for the question.
And sir, these laws and norms are reasonably driven by people and organizations. So I'll turn to Commander Wooten. What are the international and policy implications of the United States Space Command?
So I think it's interesting because what we do here at the Joint Staff is often we're act as the go-between between combatant commands. And so ultimately, the first implication is that you have United States Space Command having an equal seat at the table, if you will, with all of the other combatant commanders, which also gives him, the commander of U.S. Space Command, the ability to go directly to the SecDef as needed, as he needs to propose operations in his domain. I think one of the most interesting parts about U.S. Space Command is that, it is a geographic combatant command. And ultimately, when I talk to other combatant commands, they seem to have a really hard time, computing that and seeing how that works with the other combatant commanders. They're very used to the idea of SOCOM as basically having a force provider function. And so some people think Space Command, is that force provider? Is that all they are? And we say, no, not at all. And then they also think of, well, is this like STRATCOM? Is this like CyberCom? And we go, no, it's different too, because no kidding, you would not want to do, fires into, PACOM would never do fires into a UCOM AOR without talking to UCOM. Well, now that you have SPACECOM, no one should be doing fires into SPACECOM without probably talking to SPACECOM. And so ultimately, I think those are some of the issues that everyone's dealing with is trying to conceptually understand the way that Space Command ultimately both supports other combatant commanders, or in some cases is going to be supported by other combatant commanders.
Thank you, sir. And I'll briefly pause to see if any of the other panelists would like to add anything to that question. Our next question is going to come back down from the combatant command level into the mind of our space operators for a few legal analysis exercises. Ms. AJ, what does the flowchart of analysis look like for a space mission?
So, for a space mission, the first question in examining any operational proposal is, does the commander proposing it have the authorization? So you first look at extant exorts, and then if there's nothing there, you look at generally the plans, which will tell you that the combatant commanders all have plans on the shelf that deal with particular situations, and they may not have an exort. May not have a Secretary of Defense execute order saying, okay, you can go ahead and do the things that are in that plan. You're going to have to come back to either the Secretary or the President to get particular permission, right? So if you don't have an execute order in place, but you have a plan that's on the shelf, basically your combatant commander who wants to do an operation, or your lower level commander wants to do an operation, goes to the combatant commander and says, I think this would be a really good idea. Can I get authority to do that? And that's when the combatant commander's working team goes together and says, boss, you either have the authority to authorize it because you have some kind of a delegation, and not all delegations of authority are found in exorts, although that is the more common way to find them. Sometimes there are other documents that have embedded in them authorities, including approved plans. If there isn't any authority, an examination needs to go forward to look and see. So what are you looking for? First of all, as I said, you look at the basic authority. Is there an execute order? Secondly, you look at what are the international implications of a particular operation. Is this something that is against another nation, another nation state? Does this somehow, what are the international law implications of the activity? Are we going to be interfering with somebody else's stuff? Are we going to be moving into somebody else's territory or having an adverse effect on somebody else's territory? What does that mean for us in terms of what our status becomes vis-a-vis whoever the target entity is? So one of the things, for example, that people forget about is the law of neutrality. We have an ally who says, hey, help a brother out. Can we do that without putting ourselves into, first of all, have we made some commitment under treaty law to provide that kind of support? And so does the president have to decide, yes, we are going to provide that support or not to provide this support? But then secondly, what are the implications of providing that support? Does that move us from a neutral state vis-a-vis whatever's happening between the ally and their adversary and move us into make us then suddenly part of the conflict, or is it support that can reasonably be provided? So you start off with the internal to DoD. Is there authority to do the proposed operation? You then lift up and go, what are the legal implications for the country under international law to do this operation? And then finally, who can authorize it? I really welcome some additional comments from my co-panelists.
I could add one piece to it there, kind of a precursor, I'd almost say, to that first component of identifying an authority is characterizing the activity. And sometimes that's really easy and very straightforward. And in the space domain with ever-changing technologies and really just frankly a maturing military force, the tactics, techniques, and procedures are also developing. And so sometimes when there's a proposed operation, it may not really be clear just how that would fit within the existing framework for current authorizations and delegations. And so that goes, I'm cheating here and going back to one of my points in the beginning is that's what makes it so important to be able to relate to those operators and understand what it is they're actually talking about would happen. Because there's a lot of very, very smart people in working in this field and very creative. And so, we don't want to get in the way, but we have to be, obviously we have to be consistent with the delegations authorizations as they're stated in policy. And I think, just to kind of expand on that or add on to a question we saw in the chat there related to what goes into legal reviews. So one of the things that you might see in a legal review is to avoid the hearsay problem that Ms. AJ is saying, or really just to make it a little bit more of a complete and readable document. Sometimes you might see diagrams, like I said, that we'd have somebody draw it up on the whiteboard. Well, sometimes when we're looking at these capabilities, obviously there's a lot of homework that goes into the development of that on the service side before it's assigned to the combatant command. And so oftentimes we're digging back into that documentation to find out, well, what does this system do? What is it capable of? How can I explain that to someone who doesn't necessarily speak space? And so oftentimes pictures are helpful for that. So I just wanted to kind of add that piece on. I don't want to say it's like a left of the analysis that Ms. AJ was talking about, although I agree obviously 100% with the roll up that she had there too.
Cadet Brown, I can tag on to that one in terms of the legal reviews and a question from the audience about potential hearsay and facts and whatnot. So you're planning with your planners, your operators going into something, and someone, let's say, says, okay, we're going to exercise or this, let's say, capability. We have tactical control over these units. Here are our partners who are all tracking, they're all witting, they understand what's going to happen. X person has the authority to decide why during this operation. And we're going to execute it this way, basically. Here's what it's going to look like. And so while that person at that point has addressed your potential legal concerns, they've issue spotted, if you will, like all of us learned how to do in law school. I would compare it to, and not to ever denigrate people out there on the front lines that are working through the questions, but it to me sometimes is like if a patient walked into a doctor and said, I have arterial blockages and I know that's the problem, so I've got it under control. And so that doctor might want to do some tests to verify, so they'll trust the feedback, and that's very helpful. But you have to get to the bottom line of the facts, like Miss AJ was talking about. So you're gonna want to know, okay, I have to check the orders and delegations and fragmentary orders, execution orders, to figure out who actually has tactical control based off of what circumstances, because they've told me what their interpretation is, but at the end of the day, that's an interpretation. And at the end of the day, our legal reviews are going to be the go, no go in a lot of situations that commanders use. And let's say, all the partners are tracking, as was said, okay, let's get that in writing. Let's get witting letters. Let's get some sort of feedback from our partners that are going to be doing it. And then who has authority to make X and Y decisions. Again, let's look at the documents. Let's look at how the orders have shaken out, how the plan, and then when they talk about how the physical capability is going to be used or executed, that's where you got to ask for a concept of operation. So all these people understand and know the importance of creating CONOPS for everything that they're doing at the operational level. Those are what everybody's going to review. So I've got to see the CONOPS, and that's where the planners and operators have to really spend the time to just lay out for everybody in an approval chain, let alone a lawyer, to exactly what is going to be done. And then you can analyze that within that body of law, all of it that's applicable, whether it be international law, customary international law, treaty law, your orders specifically, your governing documents, your DODIs and DOD directives and things that have come from above. And you have to parse all through that and look at that CONOPS and fit it into that puzzle and say, okay, yes, this is good to go. Or actually, I do think there's an issue there. So I guess it's a trust but verify. That's a simplistic way of saying it. But you've got to know to ask the questions and kind of know where ground truth is in the answers. And that's how you conduct those legal reviews, even if the operator or planner has told you that they've addressed the issues. Over.
Commander Wooten, did you want to add to that question?
What I was going to add to was something that Lieutenant Colonel Wolff had said about, because I think it's actually a really good practice point when he talked about using diagrams and pictures in space legal reviews. The one thing to keep in mind for folks that might be at a combatant command or they might be at a component to a combatant command is the legal review and the CONOP just don't go from, lawyer with space portfolio to the next level of lawyer with space portfolio on up the chain to Miss AJ and then to the general counsel. Often it goes to the side or, outside of those kind of tech chains. And so what will happen is I'll have the space portfolio at the joint staff, but because ultimately the chairman is going to be giving advice to the SecDef, the chairman's lawyer is going to need to see this, which means the principal deputy is going to need to see it. And so you spend time discussing very briefly, succinctly with that little amount of time you have to prep your boss. And often those kinds of diagrams and pictures that accompany the legal review and help explain the legal review can be critical. And I say that because I think it was last week, I was explaining to someone who had very little space law background, a proposed operation. And it was because a space law attorney had provided those the diagrams and sketches to where it right away became apparent to that other senior, very experienced attorney. He could very quickly go, okay, yeah, nope, I get exactly what this is saying. And it saved a lot of time explaining that concept. So I just want to footstomp that is an excellent practice point to do.
Thank you, sir. And then I want to pull this question a little bit further one more time with Colonel Wolff and ask, when my commander is building a space mission, how do I parse which other combatant commanders should be included in the mission planning?
Yeah, so I kind of mentioned a little bit of that in my opening remarks too, that the essentially identifying who else would have equities in it. And so there are a handful of ways to think about that. One is, where are the systems operating from? So if we're talking about a terrestrial system, if it's not in, it's going to be located in some combatant commander's AOR. And so immediately that combatant commander has equities, obviously. If we're talking about something on orbit, you could think about, well, what are the effects of the operation, both, I'd first look at the effects of the operation terrestrially. Where does it have effects? Most people here may or may not be familiar that, if we're talking about a communications satellite, it could have all kinds of signals on there going to very covering a very wide swath of the surface of the Earth. And so that, they don't know the way the Unified Command Plan divides up the planet, right? So you could be looking at an operation that supports one combatant command that could easily have collateral effects in another, depending on how it's executed. And then, another thing to think about is we're not talking a whole lot about things on orbit, but if you're talking about an activity that could potentially cause concerns for another object on orbit, then you'd want to look at, well, what is the basics of Article 6, the Outer Space Treaty, who's the Article 6 state or states that have an interest in that particular space object? Where are they located terrestrially? What are the and then what are the equities that combatant command would have for implicated by that operation as well? Because it's all, the space domain is its own physical area, obviously, but just about anything that goes through there or happens there is meant to have some effects on Earth. And so military operations are no different. And because of that, you're going to need to account for where are those occurring on the surface of the Earth. And then you kind of look back for which combatant command's AOR is it. So yeah, I think I'll leave it there for now. All right, thanks.
Thank you, sir. And I'll turn now to our audience has many wonderful questions. And so I'll pose the first one generally to the panel. What will be the combat principles of space operations?
Well, I could start there. I mean, I think the basics is that we're going to comply with international law, including the law of armed conflict. Obviously, some of that may look a little bit different. One of the principles of the law of armed conflict is unnecessary suffering. So if you're looking at just in the space domain itself, at least at this point, that's not a particularly weighty consideration for most of the operations we would think about. Although it's not something to be ignored, obviously, if there is an effect either there or terrestrially. But essentially, we're going to comply with all relevant international law when we're looking at what combat operations would look like involving the space domain, whether that is something as fundamental as the UN Charter or the law of armed conflict, or even some of the more specific treaties. I know, like, for example, Professor Vonderdank mentioned yesterday the NMOD treaty, so I wouldn't say the fundamentals, at least from a legal perspective, would be any different. And again, Professor Vonderdank worked through some interesting thoughts yesterday of how the Outer Space Treaty, what effects an armed conflict would have on it. But in general, I don't perceive a whole lot of different legal basis or legal principles that would be considered, other than, like I said, maybe something specific like the NMOD treaty. But I would, obviously, application could be a little bit different, or in some cases it could be the same.
Major Zellner, sir, did you want to add to that question?
Yeah, thank you so much. So this kind of addresses another question from the audience talking about balancing operations and capabilities with LOAC, and how does that balance work? And similar, talking about combat principles, what are you grounded in? I think kind of the answer is similar to both. And that is, when you're balancing potential operations or capabilities or forward thinking what if scenarios are happening, you, as Colonel Wolff was saying, we have our body of law. We have law of armed conflict, where things happening in conflict. Outside of conflict, you'd have the law of self-defense. You'd have the doctrine of countermeasures. You'd have doctrine of retorsions. You'd have all these doctrines available based off of the type of activities from, let's say, a nefarious actor, whether it be lawful or unlawful conduct, and then the options that are available within the scheme that we're in, whether that is, again, in conflict, outside of conflict. So that's a good thing, because we're essentially applying LOAC, and we're looking at Additional Protocol 1 of Geneva Conventions. We're looking at necessity and proportionality, humanity, distinction and targeting. We apply those same things. The bad part is we don't necessarily have 4,000 to 5,000 years of history of warfare, whether that be on the sea or on land, to help apply and inform. We don't have decades of ICJ opinions on this, so we do have to extrapolate. But at the end of the day, the same principles are going to apply. And one of our big jobs as legal advisors is to then try to wrap our heads around applying that in a space context. And as all the other legal advisors on the panel have said, it applies to space as it would any domain. But then you think about those finer points as far as what does necessity look like in that space context? What does proportionality look like in the space context, which is big because you think about collateral damage on orbit and the horrible impacts of space debris that we've actually seen from certain tests as demonstrated by some countries. And then also, what does it look like in terms of impacting signals? As Colonel Wolff said, we can affect, or a country could affect a satellite that actually could really impact unknowingly a signal halfway across the planet. So proportionality looks a little different, and humanity maybe looks different when you're thinking about affecting something where you have humans on orbit, where a fleck of paint can blow a hole in something because you're going at tens of thousands of miles an hour speed. So in applying it, you're going to apply the exact same LOAC and doctrines of countermeasures that you'd apply, but you have to be able to wrap your head around extrapolating it and then preparing, as I talked about before, your decision makers with if X, then maybe Y or maybe Z, and here's what we're looking at. And commanders will often come to you with courses of action or potential courses of action, and giving them the lanes in the road of each of them and saying, here's what we have, here's what we don't have. So you're going to apply the same principles. It's just whether or not you can first process them in the domain that you're talking about, and then synthesizing all that information and then presenting it with those firm COAs. Because at the end of the day, it's easy for a lot of people that are way far attenuated to give opinions on things. It's another when you are presented with 3 actual courses of action that may or may not be taken, and you have to opine them with essentially a thumbs up, thumbs down. And so you have to be able to wrap your head around all of those factors and then just apply them to your domain. Thank you.
Commander Wooten, sir, did you want to add to that question as well?
Well, the one thought I was going to add is one of the great ways to educate commanders on these types of issues, how we're going to apply the law of armed conflict and all of these laws to the space domain and to joint warfighting generally, is when you have an exercise opportunity. Whether it's just an exercise, let's say at the combatant command level, that's only the combatant command, or it's an exercise where we're with allies and partners. I mean, these are just excellent opportunities for lawyers potentially to get with the people that are coming up with the way the exercise is going to be conducted, and to take these kinds of situations and plan them into the exercise, so that way you can reinforce how the law of armed conflict and other important laws are going to apply. And then it allows people to focus on those other kind of, whether it's policy discussions or commander's discretion discussions, and have those conversations either as a joint force or with our allies and partners. And ultimately, everyone says, we don't have 5,000 years of practice in this area like we do for law of the sea, but the way to correct that and the way to kind of figure out these issues and get people familiar and comfortable with them is through the exercise process, and telling people, hey, we have to build space, operations into our exercises.
Thank you, sir. Our next question will be for Ms. AJ. Do we over-compare outer space to traditional domains such as the laws of sea, air, and land?
Well, I'm not sure we can over-compare yet because we haven't been doing much comparison to date, right? But I think this is where you know, Matt Zellner's point is very important, and that is that, you know, it's great to look at the exemplars from the other domains to help frame our legal advice and our legal analysis for space operations. But I think he's said it quite a few times now. The physics of, and I said it in my initial comments, the physics of space matter on the analysis. And so it's important to remember that the practices and the legal theories that have been developed in the other domains have different parameters, right? I mean, there's even danger in taking the maritime law and applying it, you know, applying it, for example, to the air problem and air operations problems, because the air operations don't have to deal with the physical realities of the sea and again, the physics problems of doing certain types of operations and analyzing the effects of your activities with respect to those outside physical forces. On the other hand, given that we haven't really done a great many space operations, and the law, the international law applicable to military operations, the law of armed conflict, the international law with respect to peacetime operations, all of it, we look to those domains for comparable illustrations. But one of the most important things we'll have to do is to take a close look at the factual bases for the comparison, and to make sure that we're not comparing things that are, in fact, not comparable. So as with any legal problem, the factual analysis is key to be able to do a good legal analysis.
Thank you, ma'am. And Colonel Wolff, did you want to add to this question?
Yeah, I two quick thoughts to add or really expand on. One of them is, as has been discussed, the physical differences are obviously important. And if you want to talk about a specific thing, I think you think about the LOAC principle of proportionality and the duration and unpredictability, frankly, of debris. When we're talking about operations in a terrestrial domain, if you're talking about using munitions, that's something that, you know, there are hundreds, if not thousands, of tests and data collected from those tests. There's a pretty good understanding of what will happen when a munition is used in a given circumstance, right, on the surface of the Earth. You know, we don't have that luxury of thinking about what would happen if something were to cause debris on orbit, right? So I think proportionality physics drives a different look, or at least considerations of what proportionality would mean for any given operation. But I think, you know, in a more general sense, or zooming out a little bit outside of even military operations, when I hear comparisons to the maritime and air domains, one of the things that I'm always struck with is how, if you think of from an international law context, space has really developed in almost an inverted way. You know, and what I mean is the maritime domain, centuries of practice that sort of developed some customs. That's part of today's maritime law, body of international maritime law. Whereas in space, you know, really within about 10 years of the first activities by humans in outer space, we've got a body of law that is sort of the fundamental principles that we're building on as activities in the domain increase. And so I always think that's kind of it's really just kind of food for thought, that if you look at it in that way, that is one reason I think it's very hazardous in my mind to sort of compare it to other domains. One other temptation, I think, in the military legal community is to group up space and cyber. You know, those portfolios often have overlap for a variety of reasons, many of them practical. But from an international law perspective, the body of law is a lot different. Well, there is at least a significant body of space law for that in public international law, whereas in cyber, not so much. And so again, that'd be a couple of other thoughts I have when we look at it from an international law perspective, comparing the space domain with some of the other domains.
Thank you, sir. And let me echo a thank you to the panelists. We only have about 5 more minutes left in this specific panel. And so I want to give the panelists time to talk with the audience and give some closing thoughts and comments in the realm of operational law and space operations. And so I'm going to turn it over first to Major Zellner for his closing comments.
Thanks, Cadet Brown. Thanks again for having me. I know I'll see some of you all in breakout number 3. Or any of the breakouts that you all go into. I'm sure they will all be great. I'd like to just say the way that I look at it, at least having worked this for a few years here at the operational level, is I think there's a lot of anxiety in the legal community on governance of outer space and how we legally advise space, and that's been evident as we've seen here. But I guess I look at it as it's like a coloring book, and in that way, it's a shape or it's a picture that actually looks pretty similar. There are gray areas, but there are gray areas in other domains as well. What is an armed attack? What is a use of force? What is a threat of use of force? All these questions, like Ms. AJ talked about, that there are still debates over. Same with space. It's just a very, very different set of crayons, very, very different set of markers, different factors you have to think about, and different mechanics and different orders and authorities. It's all very different. But at the end of the day, the basic legal regimes, most of the basic legal regimes that we apply are similar, and then it becomes an exercise in extrapolation and understanding. But the same basic functions of an operational legal advisor apply, as do many of our governing legal principles that we use. Thanks again for having me.
Thank you, sir. And over to Colonel Wolff.
Thanks, Ari. Well, really just a big thanks to all the great questions and the folks with interest in this topic attending the panel. And to echo some of what Major Zellner is saying, the space, I feel like some of the things, at least that I've said today, have implicated that there's some really crazy technical depth to this stuff, and that if you're not interested in it or don't have that level of feeling or interest, then you shouldn't practice it. And I think that is absolutely incorrect. I agree with everything Commander Wooten said about how important it is for an operational legal advisor to have at least that fundamental understanding of the body of space law, not be intimidated by that there are some technical things, but when you get the folks that need to do that will get into the weeds. They'll get out the colors like Major Zellner is saying, and they'll figure out what the picture needs to look like to complete the legal analysis. And so to that end, I don't want this to come off as a technically difficult or complex that it would be intimidating to anyone, because it's not. But it does boil down to some of those differences, those physical and technological differences are where we take that existing body of law or the little bit of unique space law, and then we do an actual legal analysis and come to a result. It's not that it's its own world, so to speak. It lives within the entire body of public international law and domestic law. But occasionally there's a little bit of nuances that we work through the details to just come to the final analysis.
Thank you, sir. Commander Wooten, over to you, sir.
Thanks. Cadet Brown, thanks for moderating this. Excellent job. Again, thanks for making me a part of this panel. I guess what I would like to leave it with, given the opportunity to speak to the folks that are here watching this, many of them are space law practitioners. I would just ask, as someone who has never been at a space command and who spends a lot of time with folks that are dealing with space law issues as they deal with the cyber issues or EW issues, et cetera. I would just ask, the larger group here to please, as much as you can, educate your colleagues that don't practice space law on space law. I think it's really important at this point of where we are in space law. and so if you can have take a non-space law attorney out to lunch and have a chat with them, I think they'll find it interesting. I think they do get intimidated by the idea of having a conversation about space law, et cetera. But I think that's really critical. So I would just ask everyone, all the space law attorneys out there, please impart your knowledge to your colleagues. Thank you.
Thank you, sir. And over to our final panelists, Miss AJ, over to you, ma'am.
Well, first and foremost, Cadet Brown, thank you very, very much. You've done a truly masterful job of putting together the panel and moderating it, and I'm truly grateful. Major Zellner, what a great metaphor, and I plan to steal it a lot. Coloring books, yes, excellent, thank you. And Lieutenant Colonel Wolff, you're clearly in a great place and really appreciated being part of this panel with you, as well as with Commander Matt Wooten. I just want to reiterate what a great, great time it is to be a space lawyer, and not just a space lawyer for national security space, but to be a space lawyer writ large, because there is so much happening in civil space as well as national security space. And so I encourage all of you who are here to not only concentrate on what's happening within obviously the Department of Defense, but elsewhere. Look over the fence a little bit, take a look at what the opportunities are. But as Colonel Wolff said, yeah, there's some rocket science involved, but it's really lawyering. It's really lawyering 101, and all of us can do it. If I can do it, all of us can do it. So thank you very much for your excellent questions. Thank you to my fellow panelists for some excellent discussions, and thank you very much for the invitation to participate. Thanks.
A sincere thank you to all of our panelists for their insight, and to the attendees for their curiosity and questions. It is now my pleasure to hand it back over to one of our conference hosts, Professor Biller.
Thank you so much, Aryemis, and to our operational law panelists. That was a fantastic close to our panel sessions and clearly raised some of the most pressing operational law issues. I would like to echo the need for lawyers to understand the science, technology, and doctrine behind the operational areas that we advise on, particularly the space domain. I heard this theme throughout the conference and believe it should be one of our key takeaways. And my sincerest thanks to General Dickinson, Admiral Bernacki, General Latendra, General Endicott, Professor Vanderdunk, Colonel Huskisson, and Captain Pastorello, as well as all of our moderators and presenters who gave their time and energy to make this conference what I think we can say is a success. We had over 500 people attend at least portions of the conference, and given that attendance, there's clearly an appetite to accelerate our understanding of the law in this vital domain of operations. So many fascinating issues arose that I hope everyone has a chance to continue these conversations in our breakout sessions and in conversations and events following the conference. Speaking of the breakout sessions, once again, all attendees should have received an email with breakout links, which have also been posted in the chat. We will begin the breakout sessions at 11:40 Mountain Time. Finally, let me express my most sincere thanks for the team that put this event on. I'll start with my team here at the Academy, and I'd be remiss not to start with Major Jeremy Grunert. Major Grunert spent countless hours coordinating with speakers, panelists, and attendees to make sure that everything ran smooth, and really did an amazing job making sure everything was coordinated. Lieutenant Colonel Tim Goins is responsible for all those fantastic graphics, including the final countdown, and running all those aspects behind the scenes that most people never notice, as well as arranging all the CLE for this conference. And finally, Major Taryn Wellman. As previously stated, this conference was to be held here at the Academy initially, and Major Wellman spent countless hours arranging lodging, transportation, and facilities just in time for COVID to hit and nullify all of her work. Next, I'd like to thank our partners at US Space Command, particularly Lieutenant Commander Rasmussen, for your efforts in aligning speakers and providing substantive guidance. Particular thanks to Colonel Huskisson as well for trusting us with this conference. I hope we can continue to grow this partnership. Thanks also to Mr. Mike Hoverston. Although he is technically Space Force and not Space Command, he was invaluable in helping to provide substantive guidance and connecting us with many of our speakers. Finally, thanks to our leadership here at USAFA, including General Latendra, Colonel Vienna at the Department of Law, and Colonel Wainick at CyberWorks for providing us the time and support to put this conference on. And that's a wrap for this portion of the conference. I hope to see all of you in the breakout rooms, and for those who are able to attend in the classified session. We have recorded the various sessions of this conference, and once we edit them and get them uploaded, we will send out a link to all the attendees to let you know where they can be found. Additionally, if you follow our LinkedIn and Twitter, we will post the locations there. So to close, I hope to see all of you next year, and with any luck, we'll see many of you here at the Air Force Academy. Thank you.